the factual merits of the dispute. Without the rule of law, the assurance that comes from the independent decision makers, it is obvious that the equality before the law will not exist. Uniformity, consistency and certainty in decisions will be an accidental one. The achievement of the manifestly disinterested, the impartial applications of the legal rules will not be a feature of such a society. The constitutional provisions of a judicial branch of a government and the formal assurance that it is separate and independent of the other branches represent the main way by which most states seek to comply with the above principles. The judicial branch does not the typical include all those who, in a given society, make a decision by applying the pre-existing law to prove facts. Nowadays, there are many tribunals, statutory decision makers, and others who have that the responsibility. Nevertheless, a constitutional statement guaranteeing the independence of the judiciary is a good start. Symbolically, it involves an endorsement of the principles and makes departures from them are more difficult because they will need to be more public. Total separation of the judicial power is not possible in the real world. In many countries, the executive government appointment judges. The legislature provides for their salaries and pensions. It funds the activities of the courts. It is not necessary to be a sophisticated investor in Hong Kong or world-weary liar in Australia or the United States to realize how important it is that they conflict serious enough to come to formal decision making in a court should be resolved by a decision maker who is competent, independent and impartial. Even a person living in a most primitive society will aspire to that objective when confronted with the need to approach a decision maker. A judge without independence is a charred rat in a feral inside an operations. See, this area is the more important. What we do here in our India, as far as in India, the collegium system we are following now. Whether it could be success in the collegium system, we do not know, because after the 1993 judgments by the Supreme Court of India, in earlier occasions the judge's name will be opted by the government, and the same way the Chief Justice also recommended the name, the appointed has been made. After 93, the collegium has been formed a committee, thereafter the collegium has recommended, then that is formal by the government of India, now the appointment has been made. Whether this system is a good system or is the earlier system is a good system, which is one good one, I am giving to the lawyers, members of the legal fraternity to look into these aspects. Because why should I say, in earlier 1993, the appointment was made by the judges. Of course, to some extent, we are an acceptable one. But what is in the 2010, the recent past years, we have to look into the appointments of the entire in India, in all the high courts, how the modus operandi has been doing now. The relatives of the judges, number one, the relatives of the Supreme Court judges, the relatives of the concerned courts, and these people, and then the kith and kins of the government hierarchies. These persons have been appointed in many occasions and repeated past, since 2000 to 2000, past 10 years. It's going on, and many occasions judicial accountability we have been drawn in. In earlier occasion, the one sessions we have spoken in London in last year, we specifically pointed out in many countries, that especially in India and like in other countries in the Britain and all, when the appointment has given to the judges to appointing as judges, this area is very dry because the first the relatives and then the close associates with the judges and then friends of the judges. These persons are appointing nowadays. with certain issues we have to openly, we have to frank and then discuss, take into discussion. The person who is having a knowledge, the person who is having a capacity to deal with the law, whether they are having an opportunity to appoint as a judge, absolutely not. So, if so, then what is the relevancy to bring into the judicial reforms in the, that too especially in a developing country? How to the operation has been made? When we have to follow the other countries, how the situation has been, the appointing the judges of the other countries. These and all we have to look into these areas. That's why we are repeatedly since many years, that too especially since 2005 onwards, we are insisting the appointment made by the government, it's wrong. Appointment made by the judges, that is collegium, even that also not satisfactorily. If this be the circumstances, then who has to give? If the judicial forum has to formulate, we do not know. Earlier 1993 judgments is override, then only we can go into, otherwise it is not possible. Or otherwise you have to bring into the enactment by the parliament, then we have to do what is the satisfactions has been satisfactorily by the Supreme Court, that you have to do it. Whether these questions are all is a question even till now, nothing has been satisfied by anyone. The conversation which must supplement the textual impressions, assertion of judicial independence, reach deep into the history of each people and each legal system. In the countries of the common law, the judicial independence are received important constitutional reinforcement when the King James, he told in number 2 of England's, second England of was driven from the kingdom is the glorious revolution of 1688. His successors William and Mary were only accepted by the people on condition, amongst other things, that they promised to respect the tenure of the judges, essential to their true independence of mind of action. Suppose if comparatively those it is in Britain it is done, then if this be the circumstance, what is the formulation you are forming in India? Nothing, nobody knows. So therefore why we should include, even the James Millans say, James Madison's while drafting the amendments of the United States Constitution, which become the Bill of Rights of the country, asserted independent tribunals of justice.
Excuse me, you have 1 minute, okay?
Yes. Will consider themselves in a peculiar manner guardians of these rights. They will have imperturbable bulwark against every assumptions of power in the legislative executive. They will be naturally to resist every encroachment upon the rights stipulated in the Constitution of Declaration of Rights. So, some political scientists on the basis of experience, medieval period of the time of the colonial rule, in a particular continents of Africa and Asia, would describe the system of governance. The marvel of all history is the patience with the men and women submit the burdens of unnecessarily laid upon them in their governments. See, finally, even before concluding my speech, the good governance entitled the effective participation in the public policy making, the prevalence of the rule of law and independent judiciary, besides a system institutional checks and balance through horizontal and the vertical separation of powers and the effective oversight agencies. Democracy, liberty, the rule of law together represent the torquia that the universal accepted now as the index of civil society. Democracy signifies a government of by and for the people. The protections of individual liberties follows the notion democracy not in corollary. Thus, these aspects has been looked into even in appointments of the judiciary in a developing countries. The judiciary in developing countries, including India, has been in the forefront for safeguarding the high values, cherished traditions of democracy. Judiciary as an institution has played a major role in shaping the public opinion and perception against all forms of injustice. What we have been seen before our eyes in Pakistan is a glaring example of the institution of judiciary single-handedly safeguarded the interest of the common citizen that the country against the dictatorship. Our judiciary has also not lagged behind. It has been in the forefront fighting all the forms of evils as against the society, such as corruption, nepotism, favoritism, bad governance, and etc. People in the developing countries look upon only in the institution of judiciary as their lost hope to regain their rights. Thank you very much.
Judicial developments in developing countries, but our system is developing just like everyone else is. And I hope it will be of interest if I was to spend just a few minutes talking about the concept of the trial judge in the United Kingdom and the most recent developments. I'm sure it's the same across the world, but what do lawyers tend to talk about at lunchtime? In my long experience, the favourite topic is what makes a good trial judge. One who is invisible in the courtroom in almost every way is my own favoured analysis. Others take the view that a good trial judge does not believe that he or she owns the courtroom, but that he or she is merely a steward of that courtroom, which belongs to the citizens the judge serves. And it may be that these are the basic principles that ought to govern the development of the judiciary in any jurisdiction. As you may know, in fact I'm confident most of you will, in the United Kingdom, in the criminal courts where I practice and defend and have done for a long time, there are 13 judges, 12 laypersons, jurors selected at random, and a single professional judge appointed from the experience but perhaps case-hardened ranks of the practicing lawyer. And the theory is the law for the judge, the facts for the jury. That's the division of responsibility. And that division of responsibility is not supposed to become confused in any way. I'll come back briefly to the division of responsibility shortly. In the United Kingdom, recently, by way of judicial developments, the Lord Chief Justice has decreed that judges must be responsible for far more rigorous case management, effectively to take the case from the scruff of the neck at a very early stage and to keep control of it throughout. And indeed, it wasn't more than a couple of weeks ago that a declaration was made to all judges, and I myself sit as a part-time judge, so it was directed to me also, to impose a timetable in every criminal trial for every aspect of the case. So before the case begins, the prosecutor is given 20 minutes to question the main prosecution witness, the defence 15 minutes to cross-examine, and so on for other witnesses, and so on for legal submissions, closing addresses, and so on throughout. And of course, the more complex the case, the more substantial the issues, the wider the discretion of the judge. Furthermore, as the authorities have developed and the role of the European Court has become more influential, in each and every case, on each and every issue, the judge is required to give a detailed and reasoned ruling. However trivial the argument on any question of admissibility, the days, and they lasted a long time, when judges were permitted merely to utter the words, "I'm against you," and move on, are long forgotten. And in accordance with European principle, we and judges in the United Kingdom must give reasons on every issue. The judge's principal role is that of summing up to the jury, so back to the division of responsibilities, where the jury determine the facts, where the judge must give a full-blooded legal direction on every aspect of the case, and sometimes there may be 20 legal issues which require legal directions, and where the judge is also required to, and I say required, not empowered, to give the jury a detailed summary of the evidence, quite different to the approach, of course, across the Atlantic, and furthermore, to comment on that evidence, provided the judge tells the jury that that comment isn't binding. And this is the basic framework. And once again, over recent years, there has been a substantial body of judicial comment on these matters. Judges are now far more restricted in the ambit of comment they're entitled to make. They're required to give